Good morning, I'm Gary DeWaal, and this is Bridging the Weeks from May 22nd to June 2nd, and today is June 5th, 2017. Criminal actions naming individuals dominated news regarding the U.S. financial services industry the past 2 weeks. Last Friday, a former bank trader pleaded guilty to criminal charges for spoofing, manipulation, and attempted manipulation of gold and silver futures contracts from December 2009 through February 2012, while earlier last week, a former proprietary trader who admitted stealing his former employer's trading system source code was sentenced to 1 year and 1 day imprisonment. Additionally, 2 weeks ago, a healthcare consultant, a former colleague at a federal agency, and 3 partners at an investment advisor were criminally charged with engaging in a scheme to obtain confidential proprietary information from the federal agency and trade on it for profit. I enjoyed my Memorial Day weekend by getting away from New York City and hiking in the Hudson Valley area of New York State. Since I am now rested and full of more energy, let's get started. David Liu, a former junior trader that many media sources have indicated was based in Singapore and associated with Deutsche Bank, pleaded guilty in a federal court in Chicago on June 1st to engaging in spoofing, manipulation, and attempted manipulation of gold and silver futures contracts on the Commodity Exchange Inc. from December 2009 through February 2012. On June 2nd, Mr. Liu also settled charges brought by the Commodity Futures Trading Commission related to the same matter by agreeing never to trade commodity interest contracts under the CFTC's jurisdiction again, and never to associate with the CFTC registrant in any capacity. As part of his CFTC settlement, however, Mr. Liu was not assessed a penalty or required to disgorge any trading profits he may have realized. This was because, said the CFTC, Mr. Liu entered into a formal cooperation agreement with it, provided the Commission with substantial assistance to date, and promised to continue to cooperate with the Commission and other government agencies. According to the CFTC and the plea agreement entered by Mr. Liu, during the relevant time, Mr. Liu entered into hundreds of bids and offers with the intent to cancel the orders before execution. He did this either to facilitate the execution of an order he placed on the opposite side of the market, or that other unnamed persons associated with an employer placed. After the desired order was filled, the spoofing orders that were previously placed to move the market were canceled. In addition, both the CFTC and the plea agreement referenced that, on occasion, Mr. Liu coordinated with an unnamed trader at another non-specified major global bank to engage in manipulation or attempted manipulation in order to move the gold and silver futures market to activate resting stop orders. After the stop orders were elected, Mr. Liu would liquidate his position by buying or selling back positions to profit. In connection with his criminal charges, Mr. Liu faces potential imprisonment from 24 to 30 months, according to applicable sentencing guidelines. However, the Department of Justice indicated that it would recommend the lower sentence if Mr. Liu continued to provide full and truthful cooperation. The criminal action against Mr. Liu marks the third criminal action brought against an individual for spoofing. It sounds like more charges are imminent. 4 persons were criminally charged in a federal court in New York City for participating in a scheme to obtain confidential proprietary information from a federal agency and to trade on it for profit from at least 2012 through 2014. The 4 persons and their alleged jobs during the relevant time were David Blasek, a health insurance consultant, Christopher Worrell, a senior staff manager in the Centers for Medicare and Medicaid Services, part of the U.S. Department of Health and Human Services, and Theodore Huber and Robert Olan, partners and analysts at Deerfield Capital Management. Criminal charges were also filed against Jordan Fogel, a former Deerfield partner and analyst who's pled guilty and is helping the government. Civil charges were similarly filed against Messrs. Blasek, Worrell, Huber, and Fogel in the same federal court by the Securities and Exchange Commission related to the same essential alleged facts. According to the indictment filed by the U.S. Attorney's Office in New York City and the SEC's complaint, Mr. Blasek, a former CMS employee allegedly obtained confidential proprietary information from his former colleague and friend, Mr. DeWaal, regarding pending announcements from CMS that would impact the price of various healthcare insurance securities. He purportedly passed this specific information on to the three named Deerfield partners and analysts who used it to fashion trades for Deerfield-managed hedge funds. These funds allegedly generated over $3.5 million in trading profits as a result of the information. The U.S. Attorney's Office seeks prison time against all defendants, while the SEC seeks disgorgement and fines, among other penalties. In light of this action involving a rogue government employee, or allegedly rogue government employee, and another one just a few weeks ago involving an employee of the SEC itself, there is no wonder that so many persons objected to the proposed provision in the CFTC's proposed regulation automated trading that would have required proprietary trading firms to potentially make accessible to the CFTC and Department of Justice their trading system source code other than as a result of a lawful subpoena. David Newman, a former trader for a Chicago-based proprietary trading firm believed to be WH Trading LLC, was sentenced to 12 months and 1 day imprisonment and a fine of $100,000 for stealing his former employer's trading software and source code. He was indicted for this offense in December 2014 and pled guilty to his charges in April 2016. According to his indictment, Mr. Newman was alleged to have copied computer files for his former employer on 3 occasions in 2013 and 2014 for use by a new company he established to access the CME Group in order to speculate in futures markets. And finally, the CFTC amended its record-keeping requirements to eliminate many existing antiquated requirements and to be quote-unquote technology neutral in order to accommodate futures advances in record-keeping technology. This is a helpful new rule that doesn't lessen standards, but makes the means of compliance more flexible. All the key details are in the article version of Bridging the Week on the website. Check it out. Well, that's it for this week's edition of Bridging the Week. As always, there is more information in each article and more articles on the article version of Bridging the Week on the website. Check it out. I'm Gary DeWaal. Have a great week, and until the next edition of Bridging the Week, ciao.